I've been sick this week, but in an effort to stay productive, I dug up a piece of content that I actually created several years ago. It was initially scripted for a different project. In the older presentation, I gave a bird's eye view of living wills, or advance directives, important varieties of power of attorney agreements, living trusts, and last wills and testaments. I even briefly mentioned life insurance policies as a coda. I remembered this after my previous video for this channel, in which you'll recall I discussed talk show host Jay Leno's legal petition to become conservator for his dementia-stricken wife Mavis. In the Leno discussion, I mentioned, but didn't elaborate upon, alternatives to conservatorship. Since these alternatives, especially granting someone powers of attorney, or establishing some sort of trust, are precisely what I surveyed way back when, I thought this would be a fitting extension to the Leno conversation. So I retooled it a bit and present it now as a bundle of leads for anyone who wants to kickstart their own research into estate or legacy planning. For other relevant aspects of financial planning, please see my library of past videos, especially ones on long-term care insurance and related particulars.
Today, I wanted to talk about a couple of concepts that have to do with estate planning. When we're talking about estate planning, we're essentially talking about the making of provisions for how to dispose and handle and manage your assets in the event of your death or in the event of your total disability or incapacitation. As a disclaimer, I am not an attorney. There are lawyers that specialize in estate planning, and you should consult with a lawyer for your specific needs and applications. This is merely designed for general, informational, or entertainment purposes only. In talking through these issues, however, we talk about them as the creation of an estate plan. 4 documents are essential components of estate plans, and I'll put an asterisk on the end of that for one additional type of thing, which we'll mention at the very end. The first one is going to be the living will. Now, the living will is not to be confused with your last will and testament, which we'll get to in just a moment. A living will, and it sometimes also includes or is called an advance directive, is a statement of your wishes in the event of an unforeseen medical emergency situation. Many times these are going to be end-of-life sorts of situations. You would express what you want to have done with you and to you in the event that you are no longer able to express specific wishes concerning your care. Advance directive meaning that you are giving commands in advance of a situation happening. A court will get involved with these advance directives to ensure that the wishes are clearly expressed and that they are able to be applied in given situation. In some states, there are laws that impinge upon what a person can state his or her wishes to be and how the medical personnel can actually respond to a living will. Consult an attorney for your specific situation. A second type of document is going to be a power of attorney. One way of understanding power of attorney documents is going to be the difference between a durable power of attorney document and a springing power of attorney document. A durable power of attorney document is one that is in place permanently, essentially. A springing power of attorney document may be one that comes into effect in a given situation. A springing power of attorney might come into being in the event that you're incapacitated. So if you are elderly and infirm, you might sign a durable power of attorney giving your son or daughter powers to make decisions for you in various respects. If you're younger, you might create a springing power of attorney to make a provision that someone could assume that role in the event of your tragic incapacitation. There's also another way of understanding the division between different power of attorney documents. This is going to be the difference between a financial power of attorney and a medical power of attorney document. Just like it sounds, a financial power of attorney document is going to be one that grants a particular person, and the person granting this power is called the principal, and the person to whom the power is granted is called the attorney in fact. So the principal granting powers to an attorney in fact in a financial power of attorney document is intending that person to be able to make decisions in a financial capacity. So decisions about your bank account, decisions about refund checks, decisions about life insurance policies, and this kind of thing. On the other hand, a medical power of attorney, also called a healthcare power of attorney, is a power of attorney document where the principal would grant to an attorney in fact the ability to make decisions for him or her in a medical context. This often can complement a living will because there may be certain conditions or certain situations that arise that your advance directive or living will did not range over. It's difficult to foresee every eventuality. So in order to make sure that your estate plan, your final plans are as seamless as possible, it's often a good idea to have both a living directive and someone appointed as power of attorney in a medical situation. A third type of document is going to be the living trust. Now, a living trust is just one of many types of trust. I'm going to get into this in greater detail in other videos. I have gotten into it in a bit of detail in some other previous videos. Suffice it to say that a trust is a vehicle into which somebody places property, transfers property, assigns property. There's various different names for it. It has been said that there's only two ways to avoid probate, which is the court that handles your assets and property in the event of your death. The first is to own nothing, and the second is to have a living trust. Now, it's somewhat tongue-in-cheek. When you die, property that you own has to be assigned to a new owner by a probate court. You may have a last will and testament, which we'll speak about in just a moment. But even if you have a will, the probate court is going to have some say in making sure that your wishes are executed properly. There's a caveat, another asterisk here. If a person has very little property or under a particular dollar threshold and you have to check on your state, consult an attorney. In that case, the probate process can be sometimes short-circuited, avoided altogether, or fast-tracked. But in general, if when you die, your property has to be overseen by a probate court, if you can instead transfer ownership rights to your property into a living trust, then when you die, the owner of the property doesn't die because the trust owns the property. So the idea behind a living trust is that it provides continuity of ownership. If you die, the trust lives on. Because the owner, the trust, has not died, the probate court does not get involved. There are essentially three people involved in a living trust. The first would be the grantor, the person that places property into the trust. The second is the beneficiary, or the person or persons for whom the property is placed for their benefit. And the third person is a trustee, and it can be several people. Often a living trust is going to be a special case in which the grantor, the beneficiary, and the trustee is at least initially the same person or people. For example, a married couple might grant their property into a trust, which is set up for their benefit, and also they are the co-trustees. So they are the grantors, the beneficiaries, and the trustees. But then what they would do is to arrange for somebody to be a successor trustee in the event that one or both of them passed away, and that would be specified in the trust document. Consult your lawyer. The fourth and final vehicle that we'll discuss now as part of an estate plan is going to be the last will and testament. This essentially expresses your wishes concerning your assets and property, your worldly possessions, in the event of your death. Sometimes it can also make reference to dependents, sons or daughters that have not yet reached the age of emancipation. But all of these documents together are going to form an estate plan, and there can be many more besides. As I said, the asterisk from early in the video was a fifth thing that is essential for estate planning is going to be some good life insurance strategy. A life insurance policy is going to be a way that many families choose to fund things like special needs policies. These things can repay the family after the estate taxes have been paid, if those are applicable. The estate tax exemptions are quite large today, so it doesn't apply to many families, but it does have the capability of doing that. It has the capability of providing legacy. This is not the place to go in depth into that, but I would add that as a fifth vehicle. Now, I plan to do a deeper dive into some of these topics, but for the time being, I just wanted to survey the lay of the land and help you to get a fix on some of the things that might be necessary for your own estate plan. If you found something of use in this video, please like it, subscribe to the channel, and check back for future content. Thank you so much.